All right. Well, we'll go ahead and get started. I want to welcome everyone to the Judiciary Non Civil Committee meeting for July 23rd, 2020. This committee has been working to review the Georgia Citizens Arrest Law to better understand the legal history of the statute, how it's applied in practice, and whether repeal or reform of this code section is appropriate. First, I wanted to begin today with our meeting by giving you some committee news, which is really sad for us on our part. Hanifa Salim has been this committee's outstanding administrative assistant for the past two legislative sessions, and she is leaving us to begin law school at the University of Miami this fall. And so we are very excited for her and wish her the very best, but we are selfishly sad that she's not going to be with us. But thank you, Hanifa. She is joining this call a little bit later today, but certainly if you email with her or speak with her, please wish her the very best for the future. To help with scheduling for these meetings that we are having and plan to continue to have during this time out of session, Sadie Mcintyre, who is an outstanding student who lives in the district that I represent, has agreed to step up and help the committee. She's also the granddaughter of former House member Chairman Buddy Hardin. And so we're so excited to have Sadie helping us. And if you receive an email, committee members, from Sadie, please take the opportunity to thank her for her help with the committee and to help put these meetings together. So we have 4 witnesses scheduled to testify today, and I expect that committee members will be able to ask questions if they want to of any of the witnesses who testify. If you would just use the raise hand feature that is available here in Zoom. If you want to ask a question, I'll recognize you, just like we're meeting in person, and you'll have an opportunity to ask your questions. If we have time today at the conclusion of the witnesses, then committee members will have an opportunity to give discussion about this issue that we're hearing testimony about. And so if you'll also use the raise hand feature, then I just ask that if you're not speaking, if you please make sure that your computer is muted so that we don't have noise over the witnesses testifying. So at this time, we'll jump right in and begin with our first witnesses. Our first witness, Pete Skandalakis with the Prosecuting Attorney's Council, will be recognized first. And Pete, I believe I saw you on the call. Can you hear me?
Yes, sir.
Great,
I can
I
hear
can
you.
see you. All right, very good. Thank you, Pete. Go ahead.
Chairman Administration, thank you very much. I appreciate the ability to appear before this committee, and I also appreciate the fact that this is a Zoom meeting. I don't know that there's much I can add to what has already been discussed by Ms. Dotson last week and DA Danny Porter. You know, I was a DA for 25 years. Prior to that, I was an assistant DA for 7. So about 32 years of actual practicing as a prosecutor. I cannot think of an instance in which the citizen's arrest came into play on cases that I dealt with or the cases that were in the circuit. I do think that it's time to look at this statute to discuss, like this committee is doing, whether or not it needs to be repealed in total or it needs to be reformed. We now have trained police officers who go through, as you well know, training at Gypstick and other places, other academies, and learn everything from proper arrest to what a proper use of force is and what a reasonable use of force is. And I don't know that there's a lot I can add to what has already been discussed. And I don't want to take up a lot of time with this, with your time, with the committee's times, because I know y'all are all busy. I can answer any questions, but I don't think you would see prosecutors object to repeal of the citizen's arrest part. Now, of course, you and I have discussed this before. We're not talking about a merchant's ability to detain a shoplifter, nor are we talking about defense of habitation or defense of others, self-defense. That's not the issue here. The issue is clearly citizen's arrest, and the code that it applies 17460. So again, I know y'all have heard a lot. I know y'all have discussed this. I don't know that there's a lot I can add to it.
All right, thank you very much, Mr. Skandalakis. I'll recognize Representative McLaurin.
Thank you, Mr. Chairman, and thank you, Mr. Skandalakis, both for being here and for your valiant attempt to keep it brief. To try to complicate that attempt, referencing DA Porter's comments from the last hearing, there was a little confusion on my part because I remember from his testimony he said that there might actually be a negative or adverse impact if we amend citizens arrest somehow on use of force rules. But I'm hearing you say, and I agree with you, that there actually is no impact if we just treat the citizens arrest statute differently, either by repealing it or clarifying it, that would not affect our defense of self, defense of others rules. Can you confirm that for the committee?
Yeah, that is my belief, because you're talking about two different things. You're talking about apples and oranges. And I think what Mr. Porter was trying to talk about was when you had defensive habitation. But those situations, I mean, we can go down that slope and that road and try to come up with all scenarios. But even in defensive habitation, you're looking at a reasonable use of force. And that's completely different when a person enters your residence as opposed to a citizen who may have witnessed a crime or has not knowledge of a crime trying to effect an arrest outside of his or her residence. So I see those as two different things completely.
And the last question, if I may, is are you on board with this distinction between the idea of a custodial arrest where a person is transported from one location to another versus a detention where somebody is essentially using a proportional or reasonable amount of force in the moment to restrain somebody? And do you think that this committee could sensibly legislate the carve-outs and the exceptions we're talking about by distinguishing between that detention and a full custodial arrest?
Oh, I think you can. I think you can easily do it, and I think you can carve those things out with some type of specificity. I don't think that would be a problem, because a custodial arrest where you're taking custody of a person and then, as y'all discussed last week, transporting that person before a magistrate, as the code contemplates, are two different things than just simply detaining a person and holding that person against that person's will for some time.
Thank you, Mr. Skandalakis. It's good to see you.
Thank you.
All right, thank you. Our next question will be from Representative Silcox, Chairman Silcox, who I'm going to message Media Services so that they can unmute her.
Can you hear me, Mr. Chairman?
Yes, I can hear you. Thank you.
Very good. Thank you so much. And thank you, Mr. Skandalakis, for coming today. I really appreciate it. And just following up on the previous committee meetings, one of the questions that was routinely asked, in addition to defensive habitation, was if someone is, trying to steal your car, steal something out of your car, if you're not, it's not a habitat. Likewise, do you think that we could repeal or reform the citizens arrest statute and not have it conflict with that particular scenario or situation?
I do. I think you can handle that. Oh, I'm sorry. Representative Silcox, I think you can handle that, and you can't have a carve out for it. Again, the question also becomes, when you're talking about detention, what is a reasonable use of force? And I think that is the same thing that we're always going to have to kind of deal with. And a reasonable person. What would a reasonable person do? You see somebody breaking into your car, you try to detain that person. What amount of force can you use to detain that person? And is it reasonable? Because, a number of times you may confront somebody who's breaking into your car, and the person may be bigger, stronger, faster than you are. And so, again, it's that reasonable use of force that we're talking about, but I think you can get a carve out for that.
Thank you. I appreciate it.
All right. Well, very good. Thank you very much, Mr. Skandalakis. I don't see any other questions. Really appreciate your testimony today and the conversations you've been willing to have offline about this important issue. Thank you very much. Our next,
Chairman of Administration, I see Representative Trammell raising his hand.
I just saw that pop up. Yes, we'll recognize the Minority Leader, Mr. Trammell.
Thank you, Mr. Chairman. I was trying to figure out the technology, how to raise my hand, so I apologize for that.
No problem.
And thank you, Mr. Skandalakis, for your testimony. My question for you is, in your career as a prosecutor, how many times did you encounter the issue of citizens arrest in your tenure, either as an assistant district attorney or as the district attorney?
I cannot recall of a single instance where we dealt with a citizen's arrest. Now, I will say this, Representative Trammell. We had a policy from the time I began in 1984. There used to be situations where citizens could go in front of a magistrate and get private warrants. And they would just show up and swear out a private warrant for a person's arrest. And the policy in the DA's office at that time was we would not prosecute any private warrants without an investigation a full investigation by law enforcement, particularly when it came to felonies. I mean, there were days where citizens would show up at the grand jury and they'd be lining the hallways because they took out the private warrants. And we would routinely say, if this has not been investigated by a law enforcement officer, we're not going to investigate it. Now, whether or not they tried to effect a citizen's arrest on those cases, I don't know. I don't think they did. I think what they basically did back then in the 80s was show up in front of a magistrate and get an arrest warrant. And whether or not the person was arrested or not, I'm not sure about that. They might have waited for the grand jury. But in my situation, to answer your question, I never knew of a single case in which we had a citizen's arrest.
Thank you for your answer.
All right, very good. Any other questions from the committee for Mr. Skandalakis? All right, seeing none. Thank you again, Mr. Skandalakis. Really appreciate your time.
Thank you, Mr. Chairman.
We will next call our next witnesses from the Georgia Association of Criminal Defense Lawyers. So Mazzy Lynn Causey and Jill Travis are on the call. And if media services would please allow them to each speak, they can go ahead and present at this time. Thank you.
Thank you. Good morning, Chairman Administration and members of the committee. And thank you for inviting Gactyl to this conversation. An informal survey of our membership also reveals what you likely already know. The criminal legal system in Georgia does not rely on private persons having arrest powers to ensure public safety. Excluding detention and arrest scenarios that involve shoplifting, we received no examples of a client's case having been initiated by a proper use of OCGA 17460, Georgia Citizens Arrest Law. So this comports much with what you've just heard from Mr. Skandalakis. We're left to join others you've heard from in their assessment that attempts by private persons to arrest another generally turns out badly and that the law ought to be repealed. Any utility for allowing private persons to arrest one another in Georgia has long been exhausted. As mentioned in the last hearing, recent incidents in Georgia where 17460 is discussed involve the shooting death of individuals supposedly being arrested. Ahmaud Aubrey this year, Kenneth Herring last year. We are concerned that 17460 allows for due process to be jettisoned in favor of private individuals taking on the role of enforcement, prosecutor, and judge. As it stands now, 17460 is ripe for abuse by untrained civilians. This is a legislature and indeed a committee that backs the badge. You appreciate the training, the skill, and experience deployed by law enforcement officers throughout our state each and every day. Officers receive a wide variety of training, as Mr. Skandalakis referred to, and that includes whether and when to arrest, to effectuate an arrest, and then to what degree of force they should use. We also know, though, that even well-trained law enforcement officers get it wrong and are found by the courts to have been unjustified in effectuating arrests. We also know that assessments by seasoned prosecutors of the Ahmaud Arbery case in light of 17460 have been at odds. So when trained law enforcement officers misapply their arrest power and career prosecutors disagree on the application of an arrest law, we ought to take notice and admit that expecting our neighbors to appropriately wield arrest powers is unreasonable at best and fatal at worst. It's worth noting that Georgia law allows for reasonable necessary force to be used to prevent the unlawful arrest of yourself or another. And when you take these all together, these laws are a setup for needless violent interactions between untrained civilians, especially in light of the accessibility we have to trained law enforcement officers. As it stands now, the ability to seek timely law enforcement assistance resides in most every purse or pocket. We are no longer living in a time when proximity or force size or transportation prevent law enforcement from readily responding to the scene of an alleged offense. We think it's time for 17460 to be repealed in favor of clarifying Georgia law regarding detention. Simply put, there does remain utility in allowing certain private actors in limited circumstances to detain people. I'd like to take a moment to distinguish detention from arrest. Representative McLaurin was asking about earlier. Of course, there is a detention aspect to every arrest. Under Georgia law, a person is under arrest whenever her liberty to come and go as she pleases is restrained, no matter how slight such restraint may be. And under 174.1, it is not necessary that a person actually be touched in order to be considered arrested. Another distinguishing characteristic of arrests in Georgia is the clear affirmative directive to, without delay, convey the arrested person to the relevant judicial authority. A final characteristic of arrest is that it must be based on probable cause. This means that at the moment the arrest was made, the officer had knowledge of facts and circumstances based on reasonably trustworthy information that would be sufficient to cause a prudent person to believe a crime had been or was being committed. A detention, on the other hand, does not contemplate conveyance to a judicial authority, but it's instead a temporary situation. It falls short of arrest, but it does still require reliable information. So a police officer may stop a person and detain her briefly when there is a particularized and objective basis for suspecting criminal activity. Such detentions require more than a subjective suspicion or a hunch. They must be justified by specific and articulable facts. They cannot be arbitrary. Detentions cannot be conducted merely to harass. Because detentions are necessarily temporary, the length of a detention is a relevant consideration. Generally, whether a detention is too long a duration ties to the diligence pursued in the investigation to show that it was done in a manner likely to confirm or dispel the suspicions of criminal activity quickly. So essentially, assessment of detention duration turns on reasonableness. As I mentioned to you before this sort of mini tutorial on detention and arrest, there does remain utility in allowing certain private actors limited circumstances to detain people. The key private actors we have in mind are shopkeepers. The reality is that temporary detentions are the tool of shopkeepers. These are the retailers investigating allegations of shoplifting. 17460 is irrelevant to their work in this regard. Consider, for instance, that misdemeanors are not even a part of the statutory scheme of 17460. Yet misdemeanor shoplifting occurs every time someone takes merchandise valued at $500 or less. As was mentioned at your last hearing, shopkeepers are actually detaining, not arresting people. In practice, when they suspect someone has stolen goods or services, the store owners or their agents or loss prevention officers are detaining those people, calling the appropriate law enforcement agency, and holding the person until a police officer responds. It's the officer who then carries out the arrest. If 17460 is repealed, these shopkeeper detentions can remain lawful if the authority to detain people in these limited circumstances is explicitly provided in the law. And we have some suggestions for language that would clarify this detention in statute. There seemed to be some misunderstanding, and it's been brought up again here this morning. about how modifications to 17460 would impact our defense statute. We'd like to briefly offer our own perspective in clarifying the point. Today, under the defense statutes, they're held in Title 16, they're in Article 3 of Title 16. There is an implicit justification for using the reasonable force necessary to detain someone while waiting on the police to arrive and assist. So for instance, we believe this would apply today and allow a private person to detain someone that's caught in the act of burglarizing their home or unlawfully entering their automobile. And this remains true separate and apart from 17460. That said, we would not be opposed to further clarification in the law of such detentions and have language that we could offer the committee in that regard as well. We are so grateful that this committee is investing significant time and energy to consider the possible repeal and reform of Georgia's law as it relates to the arrest power now granted to private persons in our state. It is our hope that this effort will result in a recommendation to the General Assembly that there indeed is a need to repeal OCGA 17460 and reform our laws in order to bring necessary clarity to how, when, and by whom detentions of Georgia citizens occur at the hands of private actors. With that, Chairman, I would stand for any questions your committee has.
Well, thank you very much, Ms. Causey. Are there any questions from members of the committee? So I don't see any. Thank you so much for your testimony and providing some commentary about testimony we've already heard. I think it was very helpful. So thank you very much. All right, our next witness is Terry Norris with the Georgia Sheriff's Association, who's calling in with us here today. And so if we can unmute Mr. Thank you, Mr. Norris. Are you there?
Yes, sir, Mr. Chairman. I'm here, and I have a radio face, so I'm just calling in.
Well, thank you so much for being with us. Yes, sir. Please go ahead.
Yes, sir. Yes, sir. Thank you so much for this opportunity. You and I have spoken a couple of times about this, and I revealed at those times that the sheriffs are quite interested in participating in this discussion. It's timely, and I really, not seeing the details of any proposed legislation, of course, it's hard to commit them to anything. However, from what I'm hearing through these conversations today and some other conversations, I really don't think we're that far apart, or the opposing sides, if you will, are far apart. But I will say this. I think one thing that we should consider if we go forward with legislation is to make that distinction between detention and arrest. I think we ought to be calling these a detention, regardless of what the courts have deemed this lack of the ability to restrain movement from folks. I think we ought to be considering it to be detention. I think it is a more favorable term to the public. But I'll say this as well. We must specifically authorize under Georgia law to protect the property and the lives of people. And everybody on the call and everybody we've talked to agrees with that. But we must have the legal authority from the public's perspective, the person's, private person's, citizen's perspective, to detain those who commit criminal acts in their presence. In fact, I'm not the lawyer, as you well know, but I believe there's a 1978 case that said citizens had the duty to do so. Under Jackson, I don't have it in front of me, Johnson v. Jackson, so 76 case. So in law enforcement, we depend on interactions with the community. And no, we don't need them to do the job for us, but they are the eyes and the ears of every law enforcement agency in this country. So we need their participation. We all talk about community policing where we interact with the police. So I do think there is a role for the public in helping to enforce the law. But we also believe that private persons and citizens, if there is a detention, and our state law allows this detention, that Mr. Skandalakis spoke of it and others did too, about using reasonable force to execute that detention. Now, what is reasonable? And one might say, and I think Ms. Travis might, or one of the other witnesses may have said, you know, even police officers get it wrong sometimes, and we do. We strive not to get it wrong, but we do. So how do we expect the public to know? And I think that's that whole thought of reasonableness and what is reasonable for the situation. I don't know how we legislate that. I don't know how we write that into laws, but I do think there is a way to do that. And I think reasonable use of force can be achieved. Very importantly, we think that any detention must be immediately reported to the local agency that's responsible for that area immediately. We do not think that any transport of any detained person by the public should occur. They shouldn't take them to a county sheriff's office, a county jail, a magistrate, a municipal lockup, nothing. They should not do that. We think that if they are detained and the agency, the local agency is immediately called, that agency doesn't show up in 60 minutes or some other time deemed appropriate by the legislature, then that person should be released without further cause to be held. And then several have mentioned the use of force in defense of habitation, and that is a very important part of this whole discussion as well. So again, in a nutshell, the sheriffs want to be, thank you for letting us be, but the sheriffs want to be part of this discussion. And as I said also at the beginning, I don't think we're that far apart, any of us.
Well, thank you, Mr. Norris. I want to thank you for your responsiveness and willing to have discussions with me and other members about this issue, and for you coming on today to give testimony to the committee. Are there any questions for Mr. Norris?
Mr. Chairman, I would say one more thing, and it's almost
Yes,
a point of
sir.
levity. But several have asked about the number of times throughout one's experience that they've run into the citizens arrest dynamic, and I'll put it that way. And I was called earlier in the session, at the end of the session, I should say, by a lawyer at the Capitol wanting to know, was there a database on the number of citizens arrests made in the state? And I said, no, ma'am. And I said, I just don't really think, I don't hear about it. I've been doing this a long time. I'm not on the streets, of course, but I don't hear about it my whole career. So I said, but let me do something. I said, let me call a couple of sheriffs. I called 5 sheriffs. Each had over 40 years experience. There wasn't but one report of a citizen's arrest of all those 5. And the one that reported it was a 19-year-old, it was when he was a 19-year-old deputy sheriff in Wayne County, Georgia. He had been dispatched to some call. He was driving fast, and he looked in his rearview mirror, and there was someone flashing their lights in a pickup truck. So he stopped, and this gentleman got out. He said, where are you going so fast? He said, I'm going to a call. The man says, well, I'm arresting you. This is a citizen's arrest. You're driving too fast. So not to make light of this situation, but really, we don't know really of any cases where an actual citizen's arrest was effected. Now, there may be countless occasions or times in reports written by officers where citizens are mentioned and that citizens may have detained, and that probably is pretty prevalent. But as far as any kind of data or widespread use of the citizens arrest statute, we don't know of them. But anyway, thank you for your time to everybody. Hope everybody's well.
Thank you very much. Representative Silcox, I'll call on you if for a question or comment.
Yes, thank you, Mr. Chairman. I just wanted to thank Mr. Norris so much for all that our law enforcement do. I'm so grateful, and we need you guys more than ever. And I just appreciate you, and appreciate you coming and testifying. Thank you so much.
Absolutely. Thank you very much for that. It's our pleasure to help.
All right. Ms. Travis raised her hand here. Ms. Travis, do you have a question or comment?
I just had a comment to hopefully aid the committee in connection to Representative Silcox's question regarding the motor vehicle, and to just direct the members' attention to the definition of the word habitation as used in defense of others. It does include your dwelling, your home, your motor vehicle, and a place of business. So that's already contemplated in the code. That was it. Thank you. Good to see
All right.
everybody.
Good to see you. Thank you, Ms. Travis. All right. Our next witness that we have scheduled is Representative Carl Gilliard, who's on the call with us today. Representative Gilliard introduced House Bill 1203 during the legislative session dealing with this issue. And Representative Gilliard, thank you so much for taking time to be here with the committee today.
Mr. Chairman and committee, thank you so much for the opportunity to be.
Looks like Representative Gilliard's been muted. House Services, if you would please unmute.
Particular item that is very important to the nation. Truly, the eyes of the nation and the world are on Georgia. If we can see in the recent year of virus and in the recent year of protests and demonstrations, that the nation is in an uproar for the big word that is big but small to others, called justice. A couple of months ago, I got a call from some citizens from Brunswick, Georgia, about the incident on Ahmaud Arbery. I can only tell you that long before the tapes came out, that there was no justice. 70 some odd days later, we were able to see this particular issue come to the front line. I want to give kudos to our great leadership of Vic Reynolds and the leadership of the GBI and all of those that are in Brunswick that came together. But the unfortunate part is this is the reactory part of a citizen arrest gone wrong. Kenneth Hearing, a citizen arrest gone wrong. Trayvon Martin, a citizen arrest gone very wrong. So we hear young people say, no justice, no peace. In 1955, my brother, before I was born, was murdered in Pembroke, Georgia. A group of citizens accosted him. His name was Jerome Levant. He was decapitated, Mr. Chairman. He was decapitated, members of the committee, by individuals, not law enforcement, taking the law into their own hands. And so, years later, after seeing the trials and tribulations of my mother going through the parables of losing a son, I always wondered why. And so now we see an outdated, unequivocally outdated law that we know, and you know, Mr. Chairman, and I go back to thank the committee for saying one thing. We know that this law needs to be repealed/reformed. The question is how? Through all of the great law enforcement that has testified today and beyond, now we focus on the citizenry. Well, what is reasonable with the reasonable doubt of someone saying, you know, I think that person might have committed a crime. Trayvon Martin's murderer had taken the matters into his own hands, tracked them down after a 911 call, all the above. Ahmaud Arbery, it was a travesty. What we are looking at right now is not so much, and we talk about law enforcement, and I want to give kudos to all of the law enforcement across the nation. I have a nephew in Louisville, Kentucky that's facing the discrepancies right now, and his mother is attending rallies because she's concerned about her son. So all law enforcement is not bad. But then again, all citizens are not bad. But the ones that we have seen that have taken the laws into their own hands is a travesty. What we have in our hands right now is an opportunity to walk in a bipartisan method to send a message to the world that Georgia has no tolerance for unadulterated murder. We can count it as a lynching when we see individuals that are being hunted down like Ahmaud Arbery. What I'd like to appeal to you, Mr. Chairman, and this great distinguished committee that I commend for having these hearings, is that we put this on the front burner on not just looking at, you know, the parables of how we are going to reform it, but we've got to take it very seriously that we're not trying to take away the rights of a citizen that needs to protect themselves, because if they came into the Gilliard's home unexpectedly, they might meet Smith and Wesson and the family. But we also need to look at those that are being profiled and those that are being murdered, to the fact of people stereotyping them and taking the liberties into their own hands. Lastly, law enforcement, we must look at diversity training, because we're dealing with a generation of people now that we look at the Rashad Brooks issue, and it's unfortunate. We look at so many incidents where people are afraid. And so we need to look at diversity training on how to deal with situations, because people in the general public are afraid, and not just afraid of law, they're afraid of being scrutinized and criticized as a potential criminal. With that, I appeal to the Georgia General Assembly, the Georgia Senate, and the governor of the state of Georgia to tear down these walls and let us move forward so that we can take the eyes of the nation and let them know that Georgia has no tolerance for blatant opportunities of people taking the laws into their own hands and taking lives. Thank you for the opportunity, Mr. Chairman.
Thank you, Representative Gilliard, for your testimony. We've heard some testimonies today, Representative Gilliard, about potential repeal of the citizen's arrest statute and instead some sort of statutory language that would allow for detention in limited circumstances and with a responsibility to contact law enforcement. Heard that from really generally discussed from our first three speakers today. I guess my question for you is, in that area, and of course we all have to see legislative language to have a position on it, but are you supportive of that concept that our three previous speakers spoke about generally, or do you have any thoughts about that you'd like to share?
Mr. Chairman, my mother and father always told me to look at and listen to the
Yes.
people that were smarter than me. And in law enforcement, I'm not in law enforcement, I'm not a DA, I'm not a sheriff, and I lean to the knowledge of all of those great professionals. And I'm very supportive of amending the language in the revision of what the professionals recommend, because they know and they've been there. I'm also very proud that so many individuals from the Sheriff's Association to the defense lawyers and all of the DAs and all the above have really thoughtfully thought over this. So I'm very supportive of those amendments.
All right, I saw Representative McLaurin had a hand raised. Do you have a question, Representative?
Sure, Mr. Chairman. Thank you, Representative, for being here today, and I appreciate your bold leadership on this. And speaking of bold leadership, it would be my understanding that Georgia would be first state to recognize some of these finer legal distinctions and move away from a flawed legal structure, the one that we're talking about today. Is it your understanding that Georgia would be in a position to be the first to take this kind of bold leadership?
The gentleman truly knows from which he speaks. Georgia, and I'll say this to you all, the hate crime bill was a powerful measure, and Mr. Chairman, in the leadership of a walk, a bipartisan walk. This walk that we would be able to take would put Georgia in the lead of really taking a lead on making this particular statement. So the gentleman knows truly from which he speaks.
All right, thank you. I don't see any other questions for Representative Gilliard. So thank you very much, Representative, for your testimony. All right, well, at this point in time, we have a little bit of time for committee members to engage in a discussion about the issue. If any committee member would like to provide comments or have discussion about repeal and or reform of the citizen's arrest statute, if you just use the raise hand feature, I will recognize you. Representative Reeves.
Am I unmuted? Okay. Thank you, Mr. Chairman, and thank you to the committee. This has already been stated, but I think we're actually really close on what feels like consensus on this issue. And I think that we clearly have heard a lot of testimony that shows how infrequently, or frankly, if ever at all, the citizen's arrest portion is actually used, and that when it is used, the opportunity for something to go wrong seems to be very prevalent. And I think that what I'm encouraged by about, and I made clear in the last hearing that there are a few issues that are very important to me as far as being able to make sure that, the homeowners and property owners have the right to detain somebody until the authorities arrive, and obviously the shopkeeper stuff. So I think that we actually are really close to consensus on this, and that's encouraging. But what I want to encourage us to do further, though, is to, if there's an opportunity to clarify and improve the other laws and code that seem to cover these concepts of detaining someone while in regards to their violation of your property. One of the things I'd like to look at is that if we can even clarify those code sections to make them more clearly stand for what they stand for, and that the parameters are clear, that they can't be misused for something else, then I think this is a good opportunity to do that as well. And frankly, with the entire concept of the shopkeeper and loss prevention officers and that process, perhaps there's a way that we can even dive in and look to improve those areas of law. Anytime we have the chance to create clarity, I think that it's a positive thing. And especially knowing that, every major retail store out there in every state in America, has, I guess we'll limit it for our discussion to Georgia, has so much invested in their loss prevention program, and, in dealing with retail shoplifting and theft, that perhaps there is a way that in looking at this issue and looking at the repeal that we're looking at, we can also improve what it is that our laws allow on shopkeepers and on homeowners and property owners. So I'm very encouraged by where we are on this, and I think that we are at a good place to be able to bring something next session that is going to be needed and also improve our laws. So thank you, Mr. Chairman, and thank you to everybody that's been involved with this.
Thank you very much, Vice Chairman Reeves. Do any other committee members have comments which they wish to share with the committee or want to discuss the issue? Committee Secretary Gravely will recognize you. I think you'll have to unmute your microphone. There you go.
Okay, can you hear me okay?
Yes, sir.
I just had a question. I would, number one, I want to tell Representative Gilliard, I can't imagine what your family went through. I would definitely not call that a citizen's arrest or detention. I'd call that murder. And the same with Ahmaud Arbery. He was shot down in cold blood. And there's no excuse. There's no justification. There's no... There's nothing in our law, I think, that gives anybody the right to think they can go and do that to an individual, a citizen here in our state. I did have a question, and it's a story. In high school, I used to work at the Kroger in Smyrna with a lot of other high school guys and gals. And we had been, there had been several robberies or burglaries, I guess, thefts at the store, and the store manager knew about it. We were all on alert, and one day, and my question is, what would happen in a scenario like this should the law be repealed? One day, one of the cashiers was handed a note that said, hand over everything in her cashier box, or she would be shot. This was in 1991. And none of us knew it because the note had been passed privately. What we found out was we saw our store manager head out the door after someone in a full sprint. As we saw the commotion, those of us working, bagging in the lines or stocking the shelves, ran out into the parking lot literally we saw 20s and $10 bills and $5 bills flying through the parking lot. And we saw our store manager with an individual in a submission hold yelling to everybody around, please call 911, please call 911. The individual was detained. The bag of money was recovered by myself and other employees so that it wouldn't continue to blow. I think it ended up being about $5,000 to $6,000. The police did arrive. The individual was detained, was held in a submission hold until the police got there. But the robbery stopped at that particular Kroger. And my question is, in a situation like that, how would someone be treated, or what would be would there be any type of criminal charges put onto that store manager who had a duty to? We didn't know if this individual, was truly armed, would truly do something to harm one of the employees, and was robbing the store, we believe, 3 previous times. And so my question is, what would happen in an instance where no one was murdered in cold blood, but yet there was detained until law enforcement could get there?
So what I do is I would ask Ms. Causey or Ms. Travis if they could answer Representative Gravely's question in the context of the arrest versus detain discussion that we were having earlier.
Right. So what you're describing sounds to me like it would fall within the auspices of a detention under the concepts that we've been talking about wanting to maintain with respect to shopkeepers. You do get into what's been discussed earlier. Mr. Skandalakis mentioned that there are going to be concerns around the reasonable use of force, but it sounds to me like you would be in a situation where that would be a recognized detention by a shopkeeper. Assuming that the legislation that gets promulgated through this process seeks to maintain that type of detention. But I can't speak to it more than that, and I wonder if Mr. Skandalakis might want to add anything, or.
And I think, if you don't mind, I would add also that I think that the use of force that's allowed under the 16(3)s, because it's a place of business, that's covered under current law. You've got a theft from a place of business, you're creating, that's been created. So I think it's covered there, but we're the defense lawyers. We're representing the gentleman that's been apprehended. So maybe Mr. Skandalakis can provide some insight from law enforcement.
While you're unmuting, Mr. Skandalakis, I guess I would also just want to specifically clarify, Representative Gravely, that a repeal of 17460 would not impact anything about the scenario that you're describing. I believe it would be handled in the future. If that law was repealed, I think it would not change the way it's handled. These issues of detention and arrest and use of force are the same with or without the citizen's arrest component.
Yeah, as a prosecutor, there's no way I would ever bring charges against that manager who acted in that manner. To one, detain somebody until law enforcement got there to investigate the case and to take that person into custody. And I think that's exactly what Terry Norris was talking about, is making sure that we take into account those scenarios, because Representative Gravely, I could also use, because earlier I had told Representative Trammell that I was not aware of one citizen's arrest, and I'm still not aware of one citizen's arrest. I am aware of situations where a homeowner has detained a person breaking into their house, and that homeowner has detained them at gunpoint until police arrived. And so I agree with Ms. Causey and Ms. Travis. I don't think that is a citizen's arrest. I think that is a detention of a place of a merchant and doing the place of business. And I think that would not be a prosecutable case. There's no way I would prosecute that case.
Thank you.
All right, very good. I'll call on Representative Reeves.
Thank you, Mr. Chairman. Just to piggyback off that, and I think that one earlier when I was talking about looking at these laws and seeing if there's an opportunity to improve the shopkeeper privilege and the right to defend property, that's exactly the kind of angle that I would like to look at it through. And I understand Mr. Skandalakis, from his perspective, would choose to not prosecute somebody in that position. But, we have, 60 DAs across the state and also some Solicitor Generals where that's a subjective decision that, and I think that what our duty in this, as we look at repealing one area of law, but also trying to ensure that the other areas of law cover the policy that we think is the right policy, I think that it may be incumbent on us to clarify or work within those laws to strengthen what the policy intentions are, so that it's less of a subjective decision by a DA on whether or not to prosecute somebody in that fact pattern based on their subjective point of view about reasonable or unreasonable force, which can really be a matter of opinion. And so I think that is exactly the kind of thing that we need to look at as we look at the other side of this coin and working on these statutes for next session. That's all I got.
All right, thank you very much. Okay, well, I don't see any other hands raised for discussion at this point. I want to thank the committee members for their time. We expect that we are going to have we're going to have future meetings, and we'll be announcing those dates here very soon. I want to thank all of our witnesses today for their time during this committee hearing and also offline with the great input that was given here today. If any committee members wants to have further discussion offline, please feel free to contact me so that we can have those conversations as we begin looking at potential legislative language to actually consider going forward. So we're right up on our 1 hour time allotted for today. So really want to thank everyone again for your time, and the meeting is adjourned. Representative Kendrick, did you have something to add?
No, I just wanted to thank all the witnesses. And I remember there was a request, or somebody said they had some proposed language. Is there a way that we can get that proposed language?
Absolutely. What we plan to do is distribute language when stakeholders have given comment and it appears that there's something that's been prepared by legislative counsel to send out to committee members. So I just ask for everyone's patience, but as soon as we can, we will get that to committee members so that we can begin to actually deliberate and discuss, if possible, in these study committee hearings, so that legislation will be ready to go in the next legislative session. All right. Well, thanks again for everyone being here, and we're adjourned. Have a great day.